Greetings, this is Management 430, Human Resource Management, and this lecture is on EEO law. So we're going to cover all the major EEO laws you need to be aware of for this course. Some of the stuff is included in the text, and some of it goes a little bit beyond the textbook, but that's the plan of attack right now, is giving you a wide variety of issues that you need to pay attention to when you're managing the legal side of the HR function. So there are three basic areas of the law. I'm highlighting them here because you need to know overall that we have the EEO law, labor law, and workplace safety law. This lecture primarily covers EEO law. Labor law, with those three basic laws, will be covered towards the end of the semester when we get into talking about unions and union organization and the laws around unionization. And then the last thing, the workplace safety laws, those are from the Occupational Safety and Health Administration. The goal is to keep our workers safe. So there's lots of laws surrounding how we need to keep our workers safe. But for the purpose of this lecture in particular, we're only going to cover EEO law because labor law and workplace safety law both will be covered in separate lectures later on. But I wanted you to be aware that when we run an organization and we think about the legal environment, these are the three basic areas that HR professionals need to pay attention to. So where does the source of these laws and regulations come from when we're talking about employment law and all the challenges that we might face? First of all, what's the purpose of these laws and regulations? Well, the primary goal is that it's about balancing the power between the workers and the employers, right? But it also is about protecting both of those groups for very different reasons. I mean, employees need to be protected from capricious behaviors by employers, and employers need to also be protected to make sure employees are not taking advantage of them and that they're actually doing the job that they're contracted to do. And so if we're thinking at the extremes, like if you only think that employees are going to take advantage of you, if you only think employers are going to take advantage of you, you have a very adversarial relationship. But if we recognize that there may be circumstances where these behaviors will occur, but our goal is really primarily to work together collectively, it's a very different attitude. It's a very different perspective in terms of the day-to-day environment of the organization. So, but by and large, the laws are there. They don't come out of a vacuum. You know, they're there because laws come when there are misdeeds, when there are bad behaviors that occur, and laws are then created in order to protect those who don't feel like they are being protected. So whether it's the employers or the employee, you know, those protections come through the law. And so one of the first sources of that is common law, and that's the basic way that our system works. It's about workplace torts or employment at will, where you can be fired for any reason or no reason at all. There's no limits to very few limits on when employment at will can take place. I mean, if you're in a protected class, and you can say, well, I'm going to fire you because you're black, or there's evidence that you're firing somebody because they're African American or black. Then, obviously there are some limitations on that. You don't fire someone who's on maternity leave, right? Just because they're on maternity leave. You can't do these things, and there are limitations on when you can do that. And we will talk much more about employment at will and firing people later on in the term, but the goal here is, with basic common law addresses issues of torts, of harming another, and whether that's a contract violation or whether there's some degree of a harm and a misdeed between individuals. Those employment at will and other workplace torts sort of cover that under common law. Other sources of the laws that organizations need to pay attention to come from the Constitution. For example, the Fifth Amendment says that people have a right to a jury trial and to confront their accusers and to have a counsel, and all of this affects us in the workplace, because if there is a law that's been violated, people have a constitutional right to a jury trial and to have a counsel and to have a fair trial, if you will. The 14th Amendment is talking about due process and equal protection, and due process is not only a legal term, but it's also a term regarding sort of what is ethical or fair. We want to give people due process. People have the right to defend themselves. People have the right to say, zero tolerance policy on this. You're not giving me a reason. You're not giving me an opportunity to explain my issues and my concerns. You're simply firing me without giving me a voice to defend myself. And so due process really makes sure that we're not just, knee-jerk reaction, getting rid of people because we think they may have done something. We need to have evidence that they actually did it. And equal protection basically means everybody is protected under those laws, not certain groups and some groups and not others. And as we get into the employment laws, you'll see how that plays itself out. Even though we think, civil rights law is about protecting women and minority groups, which primarily it does, but it also does protect white males. The goal in any sort of situation, as you'll see as you get into the stuff on diversity and diversity management, our goal is not to give opportunities for women and minorities and ignore white males, nor is it the same thing to give it to white males and not to women and minorities. It's about ensuring that there's opportunities for everybody. So equal protection means we're all protected under the law equally, that there aren't some that are more equal than others. 1984, right? Some pigs are more equal than others. That kind of thing. So our goal really is to make sure that we are protecting everybody's rights, and our employment law has to do that. So the next act is the statutory law, and again, statutory law needs to be in alignment with the jury trials, the Fifth Amendment, the 14th Amendment. Our statutory law needs to follow constitutional law. So things like the Civil Rights Act of 1963, and then it was amended in 1991, Americans with Disabilities Act, which has just celebrated its 30th anniversary, I think, 1991, 25th anniversary actually. These are laws created by Congress through a whole process of developing a bill and then having it pass both houses and the negotiation process that goes into play. Statutory law, as you know, takes a long time to get resolved. And one great example, if you recall, how long it takes a bill to become a law. I mean, just reflect on those Saturday morning cartoons, or for those of you that may be old enough to remember them, where it was Schoolhouse Rock and I'm just a bill, and it talked about a very long, tedious process that it took the bill to become a law. So be aware that these things are slow to move. So laws don't happen overnight, and they certainly, as I said, don't happen in a vacuum. They happen when there's a lot of challenges and then we realize that we need to make some changes. And while we have federal law, it's really important to recognize that state and local law also get at these same sorts of statutory rights around employment relationships, but they may be stricter than federal law. State and local law has to do the bare minimum, which is what the federal law dictates, but it can go stricter. It can do more if it wants to. So just because you understand your federal laws doesn't mean you're absolved from understanding what your state and local laws are. And a great example of this is around employment non-discrimination for LGBT employees. There's no law at the federal level, but there are plenty of states that have legislation that protects gay, lesbian, bi, and transgender employees. And there are also many municipalities that protect them even when their states don't. Now, if you work in St. Louis, you're protected as someone who's gay or lesbian because the city of St. Louis has those protections. And many other states have those protections as well. Whereas, the state of Illinois universally has that employment protection at the state level. The last area of laws and regulations is around executive orders, and executive orders come from the president, the executive branch. The president can create an order which affects federal employees or anybody doing business with the federal government, and they can make an order that if you want to do business with the government, you have to do these particular behaviors, or you follow these particular policies and regulations. And affirmative action is one of them, and we'll talk a little bit about affirmative action as we get into the material. So as a very quick review, as we said a few slides ago, the law exists to protect the employee and the employer and to balance that relationship and to have a level playing field for all parties so that things are done fairly. And what you might see in your HR department is that sometimes your HR manager is an attorney, because so much of the law influences what we do in HR. I mean, people think that a lot of times HR makes these decisions because they feel like setting up these policies, and for no apparent reason, or it feels like there's no apparent reason. But I hope that as you'll recognize as we go through this lecture, that there's an enormous amount of legalese that has to be managed when you're doing HR in an organization. There's lots of constraints and restrictions and ways to think about how do we make policies, and how do these policies affect people. It's all embedded in these legal regulations, and we need to understand this. So your role as the manager is, of course, to not step in those piles of legal garbage. We want to minimize the legal liability for the organization and make sure that we're doing everything above board. It's HR's job to train you on what those laws are, but absent being trained on them, this course is designed to give you that insight so that if you have any questions about these behaviors, you can go to your boss and say, hey, how do I handle this? Or you go to your HR professional and say, here's some concerns, how do I deal with this? And we can go in and do that. So always, if you have any doubt whatsoever about how to handle something legally, don't take it upon yourself to just solve the problem. Go talk to HR, and if HR is in doubt, then they will contact a lawyer, or you should contact a lawyer, one way or the other. But recognize that this is not something to ignore or to shrug off. The law is very restrictive in how we handle things, and you'll see this as we talk about employment discrimination and interviews and selection, and the law pops up in all aspects of how we handle day-to-day operations of employees. There are 4 major issues that you need to remember around the law. Number 1 is that laws are not written with an enormous amount of detail. They're actually written purposefully vague for a reason. And the reason behind that is because our case law, the way that our court systems work, is we create the general law, and the case law allows us to create the boundary conditions of what is appropriate and what's not appropriate. And so our laws tend to be vague because you cannot think of every possible contingency when you're writing that law. I mean, as we'll talk about briefly, in a few moments, the civil rights legislation wasn't originally going to include sex discrimination, and because it got added at such a late date, it was even more vague than when one would expect, and creating major challenges for how do we understand what is considered to be sexual harassment. It took a really long time, almost 20 plus years, for us to determine that sexual harassment is a form of sex discrimination, and that's because the law is so vague. It was really open to all sorts of interpretations. The second thing is that laws, as I said, don't come out of the vacuum. They are written to correct past wrongs, and so if there's a problem and something as bad has occurred, that's when the law comes about. So the bottom line is the laws are written not for the fun of it, but because something seems to have gone wrong, and we need to create the law in order to protect people. Lastly, the interpretation, or third, is the interpretation of the laws will change all the time. That's how our case law works. And sometimes the interpretations will drift away from the intention of Congress, and we'll talk a little bit about that as well in a few moments. But the Congress many times comes back when it does amendments, and it says, no, there seems to be some misunderstanding in the way the courts have been interpreting this, and we want to make it clear this was our intention in writing this law. And I'll give you some examples of that as we get into it. So recognize that the law is a living, breathing entity, that it changes, and its interpretations of it changes over time, and it's really up to the court system and to Congress to make sure that the integrity of the law and what its intention is stays fairly concrete. Lastly, when we talk about the relationship between the law and ethics or moral outrage, the law is always going to lag behind ethics. It takes a long time for the law to catch up to people's ethical thinking. So that's a lot of times why we have laws that are just make no sense on the books, because ethically speaking, they're not good, but the law is going to take a while to change. And so again, when we think about the laws written to correct past wrongs and the interpretations of the law change over time, laws are going to lag also in how fast they get integrated and put together, because it takes a long time to write a law. Things don't happen overnight. It can take months and sometimes years for laws to pass and to gain some traction to be able to pass and get signed into law. So because of that time frame, because of the way that our court system works, ethical outrage leads the way, and then the law sort of catches up later on. It's important to get some fundamental terminology out of the way, and one of the big ones is this concept of what it means to discriminate. I mean, technically speaking, to discriminate means to differentiate between two or more things, and that's basically what we do. We have to be discriminating when we decide who we're going to hire, whether we're going to hire candidate A, candidate B, or candidate C. We have to differentiate between them to decide who will be the best person for the job. But the term discriminate has been used sort of broadly in the HR lexicon, which when we think of you're discriminating against me, really what we're saying is you are using illegal or inappropriate criteria to make a decision, an employment decision for me or about me. And so what we're really talking about is illegal discrimination. You are illegally discriminating using my sex, my age, my ethnicity, my religion, my orientation, whatever it is, to make a decision about me. So we just want to be really careful so that we differentiate the terminology. Discriminating somebody, discriminating amongst candidates is completely appropriate. It's only when we're using inappropriate or illegal criteria that discrimination based on that criteria is inappropriate. So just be mindful of the terminology as we go forward.